It's very strange. It's a very unnatural thing. I think that people, by nature, crave recognition, but they also need anonymity. I think that human beings in general, we do better when we have anonymity because it's unnatural to be chased around like that. But yet we all want to accomplish things where we experience something where we can leave our mark.
Hello, besties. It's Katie from Without a Crystal Ball. Welcome back to my channel. Yesterday, Justin Baldoni's attorneys responded to Blake Lively wanting to have a deposition at her attorney's office. And a lot of people are outraged and angry because they feel like this is just another sign that she gets whatever she wants. If she raises a big enough fuss and does enough of a fight and portrays the Baldoni parties a certain way, then and only then she can get what she wants in the court. I'll give her this. Her attorneys are extremely convincing and they've done a really good job of trying to paint a narrative of Brian Friedman to the judge. And I do not think it's an accident. Federal court in New York is a circuit, right? It's a second circuit. That court has X amount of judges and it has attorneys that are admitted to the bar in the state of New York and so many federal attorneys that are admitted into the federal court. It's a community that knows each other. Brian Friedman is an outsider. He's from California. And while he has offices in New York, the way that California lawyers and New York lawyers do things, very different. And in many ways, Brian is playing a different game than the attorneys that are playing in New York. And he's also up against two of the biggest, most powerful law firms in the country, Manat, Phelps and Phillips and Wilkie, Gallagher and Farr. Both law firms have over 1,000 attorneys, and they are billion-dollar organizations. They have power, they have prestige, they have access to the elite, and they are extremely powerful. And Judge Lehman comes from a family where his father was a very powerful, well-connected attorney in the state of New York. He doesn't come from the world where we live, where average working class folk don't have the ability to threaten our bosses with hard bargaining. But it would appear that Lyman grew up in a way that it's okay to threaten people so long as it's, within the legal parameters. When you grow up in the world of extreme wealth and elite wealth, the rules are so different. And it would appear that she is beginning to get more and more favorable rulings because he probably recognizes his own life in her. Now, that's not to say that he doesn't go against wealthy people, but he also seems to be pretty corrupt in my opinion at this point. And that actually makes me really nervous because she is subpoenaing my bank records from Google. But it's not just me that she's doing this to. She's doing this to 16 total creators. And something that I learned just yesterday is that there's a creator that she is subpoena. Her name is Ken's, and she goes by the username Existing to Thrive. She has a TikTok account where she has 10,400 followers, but her YouTube page yesterday had 38 followers, 38 total subscribers. And when I checked yesterday, she had a total of 2,300 views on her channel. She only changed, and I had an opportunity to actually connect with Ken's along with several other creators that have been subpoenaed, like Ashley and Shasti and Andy and Lauren Candace has been subpoenaed, but I haven't spoken to her. Perez says that he was not subpoenaed for by Google. At least that's what he said. And as far as I know, Google has confirmed that this is a completely legitimate subpoena, which blows my mind on so many levels. And they have said they may produce documents, which I found kind of strange because usually social media platforms will reject subpoenas under the grounds of protecting user privacy. And they generally will say that a user is entitled to a level of privacy on their platforms and anonymity, and they don't have to hand anything over. And there's laws like the Stored Communications Act, which protects communications and oftentimes what occurs on these channels. And so I think it's interesting because Blake is only seemingly going for information about the account, not about the communications. And there's going to be a hearing later this week about extending the deadline for discovery because only Blake wants to have it open and the document discovery open until September 30th. And she claims that she wants it open until September 30th because she has issued subpoenas. She told the court that she had issued 60 subpoenas thus far, and that within the 60 subpoenas that she's issued, she's still waiting on documents from some of those subpoenas. And once she starts to get more of those documents in, then she's going to need to subpoena more accounts and more people and get more information. And really, there's no lengths that she won't go to try to basically harm everyone that she thinks doesn't like her or that has criticized her because it would seem kind of irrational that you would target an account that has, as of today, 100 some subscribers and 2,500 views, not even monetized. And that's not even the only account that's not monetized on YouTube. And Ken's is a real person, and she's a real person that's a survivor of domestic violence. And she started covering the story because she told me that she didn't appreciate the way that Blake promoted the film It Ends With Us. And she felt like Blake was dismissing victims of domestic violence and that she wanted to just use her First Amendment rights to speak about the case and cover the case just like the rest of us on social media. The difference is that she was and is not monetized on YouTube. She has no payment information set up. She's not part of the partner program. So really all she seems to be doing is just targeting 16 random people that have made content about her that she doesn't like. And to me, she knows she's not going to find anything, so it's a means to punish and silence her critics and intimidate them. And it's interesting because I feel like the more and more that she gets these favorable rulings from the judge, the more emboldened she feels that she can do and issue anything that she wants. And she can seek it from anyone. And something that I thought was odd for me was that Stephanie Jones has my name and my address and my company's name and address. And I received a letter from Stephanie, and my lawyers did too, about a cease and desist. She never sued, by the way. But Blake never issued a document subpoena to me. So my biggest question for what she's searching for in these subpoenas is, say she gets my my account information and she can look at the transactions that are going into the Google account. I don't know how she would be able to figure this out. Is she going to then subpoena every single bank account that has sent a super chat to this channel, or is she going to subpoena my bank account? Because when I make a payment to Google, it's only for Google Premium, and nobody else can boost Google videos. Okay. So the only way that you can promote your own video is by paying to advertise on YouTube. And so is she going to try to go into there and figure out who made a payment into my AdSense account? That won't show you anything because I've never boosted a single one of my videos by her. I've never done anything. I get video views and that's it. I've never advertised a single one of those videos. So no one is paying to boost my videos, and you can't boost videos by paying them without the creator knowing. And nobody has access to my AdSense account but me. And then I started thinking, is she going to try to get the bank account information for anyone that sends a super chat? And I was like, no, that can't be. Because how would she then correlate that I'm actually getting paid by anyone without documents to prove that there was an arrangement where I'm being told that I'm receiving payment for this? Because her argument in the court is that Brian Friedman has channels that he uses where he speaks to creators and he gives them scripts about what they're going to talk about. And then through these scripts and what they talk about, he pays them to make videos about her. That's what she has decided. And it's false. Every single person that has been subpoenaed that I've talked to has not been paid by anyone. And many of them aren't even monetized. So then, if she's not going to get proof from us that we've never communicated with these people and there's no arrangement for payment, how does looking at our bank accounts really do anything? This initial subpoena to Google is just one part of the process. The next step is once she gets our bank account information, then she's going to try to subpoena our banks. Then she's going to try to subpoena, our credit card companies. But what she's not doing is subpoenaing us for documents to prove that we've spoken to anyone. She has only done that with a few creators, including Andy Signor, Candace Owens, and Perez hasn't even been served yet. I took a look at her argument to the court about why she needs an extension. And here's why she's looking at us as third parties. Miss Lively respectfully submits that the court's July 25th deadline for third party production should apply to all noticed subpoenas in order to facilitate those productions without prejudice to additional third party document discovery through the close of fact discovery on September 30th, for which production is required 14 days after service. Ms. Lively has not proposed any interim date for completion of third-party document discovery on the understanding that such discovery would be warranted and permissible until the date of fact discovery, the close of date. Given the deficiencies in the Wayfair parties' document productions to date, Ms. Lively anticipates that depositions will yield further information critical to her claims, such as regarding vendors, digital teams, or content creators deployed by the Wayfair parties in connection with the retaliatory campaign, which in turn will warrant the issuance of third-party document subpoenas after July 25th. While Ms. Lively has been actively pursuing third-party discovery and indeed has provided notice of more than 60 document subpoenas to date, she simply has not been afforded the discoverable information through documents to have concluded such third-party discovery before depositions have taken place. Alternatively, to the extent that the court is nevertheless inclined to impose July 25th as the final date for third-party discovery, that precludes the issuance of third-party document subpoenas essentially as of now. Ms. Lively asks that the court make clear that additional third-party discovery may take place through the close of fact discovery on September 30th on a showing of good cause for that discovery. And then she also says she has drawn the distinction between noticed subpoenas and served subpoenas as she intends to imminently file motions for alternative service to at least Cynthia Barnes Slater, Dervola McNeese, and Perez Hilton. Because Perez apparently has not been served yet, and she tried to serve the attorneys at Brian Friedman's firm, and they said they didn't represent him. And I asked Perez why they said that they don't represent him, and he said because he'll handle the subpoena issue. He doesn't want to pay for Brian to have to do that, and he just wants to deal with it himself. So he's not going to have Brian represent him on the subpoena, which you can do. And then she says that he's taunting her. What I really, when I read through the lines about why she's doing this, it's very easy. She says that Wayfair is deficient in their document productions. You can't prove a negative, okay? So if they tell her, we don't have documents that we paid creators because they didn't pay creators, she's telling the court they haven't produced anything that proves that any creators have been paid. And that's what she's indirectly saying. She's saying she has no evidence that any creators or digital teams were paid or, you know, what did she say? Deployed by the Wayfair parties in connection with the retaliatory campaign. So she says that Wayfair hasn't provided any evidence about these digital teams. And so now I need to go to the creators to find out if they are part of the digital team. The party in the case, the direct party in the case, Wayfair, hasn't provided any evidence because there's none. If there were evidence of them deploying a third party to do their work for them and pay, they would have had to produce it. But you can't produce what you don't have if it didn't happen. So now, because she didn't get it there, she's coming to us because she wants to somehow prove that we got money and that Wayfair is lying, and that just doesn't even make sense. So she knows that Wayfair has not paid anything. She knows it as a fact because if they had it, they would have given it to her. It's kind of like the sexual harassment claims and the retaliation claims from last August. If there was an untraceable campaign, then Jed and Wayfair would have produced the evidence via document discovery to prove it. And I find it interesting that she has shifted so far away from Jed and his involvement in the digital campaign, and now she's focusing on the content creators for the ongoing. But the problem with Blake here is that, and what she has to overcome is freedom of speech. Just because someone covers a court case that's in the public domain doesn't make them part of a retaliatory, uh, deployed retaliatory digital team. It just means that she filed a lawsuit, and then that lawsuit is getting discussed, and then all the steps that she takes are getting discussed. And some of the ways that she's getting discussed are the way that she's behaving and how she's changed her story and how a lot of her claims have been proven to be false or have been refuted through evidence. And she's dismissed some of her claims because she doesn't want to hand over medical records. So, really and truthfully, she's desperate. She has no evidence, and she's going to try to will the evidence out of us. Because if she would have thought about this earlier, she would have subpoenaed all of us earlier. She also might be doing this because she wants to figure out who's leaking information to us. It also could be because she's retaliating or trying to intimidate us, especially if we've reported negatively on her or revealed unflattering legal documents. This could be a way to try to scare us into silence and force us to spend legal fees and make us second guess our coverage and make other people second guess our coverage. And that's actually called a slap adjacent move. It's not technically a slap like a strategic lawsuit against public participation, but it's an adjacent move to it. It also could be because she's like desperate. Like I said, she might be trying to, prove media collusion. But if she would have thought about this ahead of time, she would have subpoenaed everyone in the beginning because she's not going to be able to prove any sort of collusion after the fact. She just won't. Because all we're doing, at least I am, is just reading the court records. And she knows that. So to me, it's not because she knows she's going to prove anything. I think it's just intimidation and trying to silence us and punish us for speaking negatively about her, the same way that she's trying to punish Wayfair. But I mean, I wish the mainstream media would pick up on the fact that she is subpoenaing people that have non monetized channels that have made $0 and that are victims and survivors of domestic violence, because that's what she's doing. She's bullying people through this. And she's only going to be, I mean, even if she gets every single favorable ruling by the judge going forward, if the evidence doesn't exist, it doesn't exist. And a jury can't find them liable if there's no evidence to prove it. If there's nothing there, there's nothing there. She also could be trying to do this to force them to settle by putting pressure on them, like saying, see, if you keep going, I'm going to dig into all your creator friends. You better stand up for them because you're their creator friends. It's what she's doing is just, it's crossed every single line. So, as I told you, I would be telling you that I would be responding in court, and we got confirmation that it is, in fact, a legitimate subpoena. And YouTube says that if they don't get a motion to quash from us, they may produce our documents to her. For what reason, I don't know. I don't know how she's proven anything that would make them reasonably want to give us that information. And some of us have gotten together to try to work through this together to figure things out, possibly filing a motion to quash together, although it's hard to find every 16 person, but our legal fees are accruing now. And so if you want to continue to support those of us that are creators that have been subpoenaed, make sure to send super chats or super thanks or support the channels however you wish. We haven't currently set up a GoFundMe, and I don't know if we will. Crowdfunding, I don't know, but you can support the channels through chats or through super thanks for now. So what are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and to click the bell so you never miss a video. Thanks so much for watching. Bye, besties.